Please welcome Professor Eric Janus.
Well, thank you very much. Thanks for inviting me. It's an honor to be here in Connecticut, beautiful building. And I don't know, I'm sure there are a lot of similarities between Connecticut and Minnesota, where I came from, but the one I notice here is that there's hardly any black coffee being drunk. It's all regular. Anyway, so that I was very, very pleased to hear the presentation from Judge Huffman. And I think that what I have to say is going to follow a little bit, dovetail with what she had to say. And a little bit of overlap, but not very much, I hope. I want to pick up on her idea of moral panic, and I want to explore that a little bit in my talk. And I want to explore it by looking at some of the narratives, some of the what I call frames that we as a society have developed for dealing with sexual offending. And then I want to talk a little bit about, try to help us understand why these frames are harmful frames in terms of what ought to be, and I think is, our shared objective of reducing, preventing sexual violence, and why those frames are so sticky. Sticky in the sense that they stick around. Judge Huffman talked about the cyclical nature of what she called the moral panic. And we're probably now about 25 years into it. So I want to talk a little bit about at least my theories about why it's been such a powerful influence, and why now? Why are we going through this? Because believe me, sexual violence is not new. So what is it about us now that means that we've adopted these particular ways of trying to understand sexual violence? And how have those ways, those frameworks, then shaped our approaches to prevention? And are those ways that our approaches to prevention have been shaped, are they positive? Are they negative? Can we do better? And I'll just skip ahead and say that I think in many ways these frameworks have had negative effects on prevention, and we can do better. And I hope that maybe by explaining a little bit about at least where I think the power of these frames come from, we may be able to help refocus in a much more evidence-based, effective way on prevention. So what are these narratives? What is this panic? And it is about one thing, and it's about recidivism. And it's about the construction of the sex offender as a serial predator. So we have a Fox News article from a number of years ago that I think is quite illustrative. Molesters often strike again. So it's constructing this idea that sex offenders, people who've been convicted of a sex offense, sent to prison, often reoffend sexually. Criminologists say it's all too frequent that the perpetrator in such cases is a pathological sexual predator, as is true, and then it lists a number of these high-profile sexual homicides. So we see a further construction of the sex offender as almost inevitably reoffending and being pathological. By the way, those two things go together, because if you can't learn from being punished and you go right out and do it again, that's clearly pathological, psychopathic. Goes on to say, it happens all the time, said Louis Schlesinger, a forensic psychologist. The dangerous ones have a high recidivism rate. Well, of course, that's a tautology. That's what it means to be dangerous. But the implication is that there is a high recidivism rate among sex offenders. And as we know, that meme, that idea that sex offenders almost inevitably commit new sexual crimes has been embedded in our jurisprudence as well. The Supreme Court in 2003, upholding one of the early registry laws, the legislature's findings are consistent with grave concerns over the high rate of recidivism among convicted sex offenders. The risk of recidivism posed by sex offenders is, quote, frightening and high, unquote. And that meme, that notion that recidivism is frightening and high has been repeated by other courts and legislatures literally hundreds of times. But it's a myth. And one of the things that I would like to emphasize is that designing policy based on myth is dangerous. It's dangerous because it leads to ineffective and potentially harmful policies. Now, reliance on myths is not new in this area. We now have a set of myths about sex offenders, but we certainly have had in the past, and I'm sorry to say continue to have, a set of myths about rape and sexual assault as well that minimize the harm, place blame on the victims, and construct a certain image of the rapist. And I think we saw an example of that just recently in one of our president's tweets, where he says, gee, if this woman, if that really happened to her, wouldn't she have reported it immediately if it was really that serious? So again, we've had some persistent myths about sexual assault. Those myths are dangerous. They minimize the harm. They place blame on victims. And as I'll suggest, I think, particularly as a result of feminists over the past 30 years, have, as a society, worked hard to eradicate some of those rape myths from our laws, our policies, and hopefully our attitudes. But we also have now a set of sex offender myths that have a different set of harmful consequences. Judge Huffman talked a little bit about recidivism rates. What we have then is this myth that those rates are frightening and high. She suggests, and I concur with her, that that's not true. No matter how you cut it, it is simply not true that almost all people who've been convicted and punished for a sex offense commit another sex offense. In fact, what we know is that the numbers are probably significantly, orders of magnitude less than that. But it's not my purpose here to kind of go through the intricacies of counting recidivism. I think it's enough for us to know that this notion of frightening and high is a myth. So these myths create certain frames, or they're representative of certain frames, and they also lead us to ask certain questions. And I think, as with the rape myths, these sex offender myths have misled us, misdirected our policy. They've created a set of frames and questions, and I will argue, and by the way, have argued in my book, which I'm not, I just will mention in case you want to follow up, has a lot of the references, and also a more recent article that I think is now on the website of the Sentencing Commission. If you'd like to check the sources on this. But I argue that it has led us to a misallocation of resources, ineffective policies, unintended consequences, and dangerous legal principles. So I hope to explore some of those things. So where has reliance on this myth led us? That's what I hope to talk about. As I mentioned, why is there such stickiness in this myth? Why does it stay with us? How have the frames misdirected us? And how should we change our frames to improve our efforts? Summary, boiling it down, we've been asking the wrong questions, in my opinion. And when you ask the wrong questions, you get the wrong answers. The question we have been led or have chosen to ask is, who are the most dangerous people? And then we've tried to figure out who those most dangerous people are and separate them from us. We should be asking a different question, a more inclusive question. How can we prevent the most danger? Now, that might include, as part of its answer, figuring out who the dangerous people are, but that's not the whole question. So my plea is to say, let's be laser sharp in what we're asking. And that is, how can we reduce the incidence of sexual violence most effectively? Because when we ask the question and limit ourselves to who are these most dangerous people, then we necessarily restrict the range of solutions. It's not just my opinion. Association for the Treatment of Sexual Abusers issued an interesting report recently expressing their opinion, but also what they report as the opinion of victim advocacy organizations that have questioned large expenditure of funds on sex offender management tools that may not really protect communities, while resources and services for victims are being cut. So this is going to be also a theme here, and that is that, does it matter if we enact ineffective policies? Yes, it does. Why? For the very simple and basic reason that it means that we're spending money on something ineffective that we could be spending on something more effective. Minnesota Coalition Against Sexual Assault issued a statement a couple of years ago. Here's part of what they had to say. It's equally important is our collective commitment to prevention of sexual violence in all forms. And I read that to mean it's not just recidivist violence, it's all. And we'll talk more about why that distinction is so important. Ending sexual violence is urgent and highly complex. The hope and promise of prevention of future violence requires tools beyond those available to our civil and criminal justice system, which can respond only after harm has occurred. So what they're hinting at here and getting at, we'll talk more about, is this idea of comprehensiveness in our approach and the development of primary prevention tools that go for the root causes of sexual violence and reduce violence, not waiting till it happens to punish, but reduce it before it occurs. Public safety is served by prevention and true rehabilitation. So we have to change our frames to enlarge to see that prevention and rehabilitation serve safety. A dysfunctional system does not help victims. Dysfunctional systems don't do what they're supposed to do. In functional systems, victims are respected, constitutional rights are upheld, and public safety is not compromised. So my plea is to try to understand what unites, I think, all of us here, and that is prevention. Should be our focus and is I suspect, are common ground. So Judge Huffman, I think, gave a good history of registration. I want to expand the history a little bit to give us a little context. As I mentioned, our rape laws, our laws about sexual violence in this country have long been framed and shaped by rape myths. I won't go into a lot of detail about it, but beginning in the 70s, with the rise of the various feminist movements and feminist jurisprudence, those thinkers led fundamental changes in our rape law and our law of regarding sexual violence. Those reforms produced redefinitions and broadening of the notion of rape and sexual assault, new understandings of what we mean by rape and sexual assault, new understandings that were incorporated in such things as the National Crime Victims Survey that then showed a much more accurate picture of what sexual violence and sexual assault were like in this country, not limited to what traditional notions of rape had been. And these reforms also have led to changes in how victims are treated in the criminal justice system in some pretty fundamental ways. And in my view, many of those changes that were inspired by feminist reforms are salutary. Beginning in the 1990s, however, we began to see the development of another group of laws, so-called regulatory laws. These are laws outside of the criminal justice system that claim not to be punishment, they claim not to be criminal laws, but they claim to be enacted under the state's power to regulate behavior. And of course, I'm referring to registration, public notification, residential banishment laws, and civil commitment of sex offenders, which I understand you do not have in Connecticut. That's a really good thing you don't have it. And so I'm not going to really talk about that very much. So we've had these changes. We've had, I'll call these laws, these regulatory laws, innovative, even though I don't think they are very good innovations, but they're very creative. And we put a lot of energy and a lot of moral outrage into these laws, but we still have, obviously, a whole set of systemic problems. We have a Me Too movement. And what is that calling attention to? It's calling attention to, as Judge Huffman said, sexual violence, sexual harassment, often in situations of power imbalance. We have a number of high-profile situations, places like Penn State, Ohio State, various elite schools, where we've learned about systemic sexual abuse, sexual violence that's been covered up. And so what these things suggest to me, and I'll talk more about this, is that what we haven't been paying sufficient attention to, while we've been asking who these most dangerous people are, who are these serial perpetrators, we haven't been paying enough attention to the attitudes, the institutions, the practices we have in our society that allow sexual violence to flourish with impunity, as we've seen in a number of these situations. So, well, I like to go back to first principles, think about what we're trying to accomplish through our laws, get some clarity about that, and think a little bit about what the tools we have are and which of those tools are most conducive to addressing what we're trying to accomplish. And, you know, I think there are a number of things that our laws probably are trying to accomplish. They represent a societal condemnation of sexual violence. Perhaps they represent a move for revenge. A clear policy, a clear goal is, or ought to be, prevention. And when we look at the criminal law, all three of those goals might be appropriate. We might have different views about their balancing. But when we look at these regulatory laws, only one of those goals is appropriate, and that's prevention. Because condemnation and revenge are tools of the criminal law, and these are not criminal laws. What tools do we have? Reporting. Judge Huffman talked about the low rates of reporting. I'll have more to say about that. Crime solving. What percentage of these cases are reported? How many are cleared? Support of victims is a tool. Changing the rape culture. Punishment clearly could be a tool. Supervision, treatment, reintegration, separation, shaming. All of these are potential tools. Which ones should we choose? Which ones are legitimate? Is an empirical question in part, and it's a moral question. But we can't even get started on making those choices until we shed the notion that the evidence doesn't matter. So here are my themes. Where have we gone wrong? What should we be doing? Number one, as I've said, too narrow a focus. Our focus in these innovative laws, in these high-profile laws, I'm not claiming this is the only focus, but there's too narrow a focus on recidivist violence, number one. Number two, our focus has too far downstream. We're looking and spending our time and our energy and our moral outrage downstream rather than upstream, figuring out what practices, attitudes, institutions allow sexual violence to flourish in our society. We're ignoring the evidence. How many times have we heard people say, I don't want to understand pedophiles, I just want to lock them up? We're asking the wrong questions, and I'll suggest more about that. Our approaches have been reactionary, not comprehensive or systematic. And we've established the dangerous legal principle that it's okay to take a despised group of people and treat them under a different set of rules and values than the rest of us. Where should we be going? We should be having a comprehensive and systematic approach to sexual violence, using primary, secondary, and tertiary approaches. We should be seeking root causes and trying to understand them. We should be evidence-based. We should have aggressive systems for assessing what works and doesn't work, and we should be seeking to replicate best practices. If that sounds familiar, it should. It's a public health approach to sexual violence, and it's a tried and true method for addressing widespread societal issues. Now, I mentioned that we have this meme, this idea of frightening and high, that's a myth, and I've suggested that these myths are dangerous. They have consequences. So here's where I think this myth leads us, this meme of frightening and high. Number one, almost all sex offenders will repeat their offenses. Number two, sex offenders as a class, as a group, are extremely dangerous. Well, why can we say as a class or a group? Because they all behave in the same way. They all repeat their offenses. Sex offenders are wired differently. How does that follow? Because, as I mentioned before, if you never learn from your experience about being punished and you go right back out and do the same thing again, that is pathological. There's something wrong with you. We as human beings, if we're rational, we don't do that. So these people are wired differently. Number four, therefore, it follows that sexual violence is a problem caused by abnormal psychology or biology. These people are different. It leads us to think that these highly rare crimes are archetypes these highly rare crimes of recidivists murdering children, which, thank God, is extremely rare. That's seen as archetype. That is the sexual predator. Sex offenders are the other. They're monsters. Stranger danger is the model. And all of this leads us then to this notion that the thing we ought to be doing if we're concerned about prevention is identifying who these dangerous people are and keeping them away. That should be our primary concern. And that's certainly residential banishment laws do that. Registration and notification laws are designed to provide the tools for private people to separate these highly dangerous people from us. So, we have this myth then that almost all sex offenders recidivate. And what that leads us to is, I think, a central model here, and it's the serial predator model. And think about it. If almost all sex offenders commit another sex offense, then almost all of the sex offenses committed now were committed by people who were convicted before. And if we want to know who's going to commit most of the offenses tomorrow, we look at who committed the offenses in the past. That's what this serial predator model leads us to, is that there is a discrete group. It's changing at the margins, but there's a discrete group of highly dangerous people who commit almost all of the crimes. And it's logical then for us to say, oh, well, let's figure out who those people are, and that'll take care of most of our problem. But there are a number of problems with that approach. As I mentioned, it leads to a downstream focus. We ignore root causes. We don't really care why these people are doing this at some level. We just want to identify them. It casts the majority of sexual violence into the shadows. We know that most sexual violence, as I'll get to this, is not committed by recidivists. It's not the archetypal sexual violence. So when we construct this archetype of the serial predator, we are misleading ourselves and ignoring a huge swath of sexual violence. This model also leads us to this notion of the degraded other. Judge Huffman mentioned the internment camps for citizens of Japanese descent. Unfortunately, our country has a long history of picking out a degraded group of despised people and treating them differently as demi-citizens. I would point, for example, to Buck versus Bell, approving involuntary sterilization of the quote-unquote feeble-minded. It leads to the notion that these people are degraded and their pain doesn't count. And then that leads to what I would call a stunted metric for figuring out what kind of programs work. And that metric is, well, if this program, if registration can save one victim, if residential banishment can save one victim, it's worth it. We realize there are a lot of innocent people, a lot of non-dangerous people, but that doesn't matter. What matters is that we saved one victim. We spare no expense. Of course, we always spare expense. But by saying we spare no expense, what we're really meaning is we're addressing the important crimes. Those crimes, the domestic crimes, the domestic violence that are in the shadows, that we're not funding, they don't count. It leads us to ignore opportunity costs. When we choose this system rather than that system, what are we giving up? There are consequences to those choices. it leads us to ignore unintended consequences. And it leads us to ignore science because there's such a low burden of proof. If these programs do any good, they're okay. That we don't need science. Common sense will do. And therefore, there's no accountability for policy choices. Accountability for what? Accountability for whether they're doing the best possible job at preventing sexual violence, and accountability for the harm that they're causing, if there is harm. So here's where I want to talk a little bit, and this is, I think, much more speculative, about how we got here. And Judge Huffman, I think, accurately describes what our approach to these problems has been as a moral panic. My question is, why has there been this kind of reaction? Why now? I mean, obviously, we've had sexual crimes forever. What is it about our time that leads us to this particular approach, this idea that there's this serial predator, these people who are different, more different in kind, and it's okay to treat them as a degraded group? Well, I want to suggest that we're in the midst, I'm sure we always will be, but we're in the midst of a particular set of culture wars. Not right now, it's certainly been going on for 30 years. And I'll roughly describe it as a dispute for control between what I think of as feminist reformers on the one hand and social conservatives on the other. Feminist reformers have a certain approach and idea based on evidence about what sexual violence is like in our society. It's ubiquitous. Societal norms allow it to flourish. And women and children are most at risk in domestic and familiar settings, statistically. Contrasted with that is what I'll probably call unfairly, but that's what I think of it as a social conservative viewpoint, which is that sexual violence is stranger violence. It's committed by abnormal people. It's aberrational and abnormal. Women and children are safest at home under the protection of their families. Now, archetype quotes, Elizabeth Stanko, feminist philosopher. Collectively, women are more at risk of violence in intimate relations than in public spaces. Heritage Foundation. The institution that most strongly protects mothers and children from domestic abuse and violent crime is marriage. So, what to me this boils down to, and how this translates into the frames we've set up to think about our policy, is that it's one approach, the feminist approach says, folks, it's us. It's our society, it's our attitudes, it's our values, it's our institutions. These allow sexual violence to flourish. We're responsible. We need to change these things. Versus the other approach, which says, no, it's not us. We're fine. It's them. Who's them? Those serial predators over there. They're abnormal. We're normal. Just get them out of here. So I think that our policies have, and I'm not saying this is intentional or partisan, but I think these policies about registration, notification, banishment, and so forth have adopted the it's not us, it's them approach framework. And they have led us then to think of the problem as a psychological problem of individuals rather than as a societal problem of widespread values. So how have we been misdirected? And by the way, I think that's why this serial predator meme, this frightening and high, is so sticky. Because it's not just an accident that it's happened. It's rooted in deep fractures in our society and deep efforts that we have to say, actually, we're okay. We don't need a fundamental change in our society. So, how have we been misdirected? Let me go through about 5 ways in which I think we've been misdirected and we've gotten this wrong. Number 1, as I said, sex offender recidivism, well below the myth. Number 2, measured recidivism rates have declined over the past 20 years. So if you read a study from 20 years ago about what recidivism was, those rates may not apply now because we've seen a persistent decline in the rates of recidivism. Number 3, risk is not average for most offenders. So if somebody says, well, there's a study there that says that the recidivism rate for sex offenders is 30%, obviously that's an average rate. It doesn't tell us anything about this individual, that individual. And so what I put here are 2 examples of the distribution of risk levels. Minnesota, on the left-hand side, Minnesota, right-hand side, California, red being high risk, green being below average risk. These are sex offenders on registries. So we see that actually most sex offenders on registries are at the moderate to low risk levels. Number 4, risk declines with age. Risk of recidivism declines with age. It's a widely accepted principle in criminology in general, and apparently applies, unsurprisingly, to sexual violence for the most part as well. Now, these 2, number 4 and 5, I think, have special salience to what we're talking about today. Number 5, risk declines with time offense-free in the community. So we have 2 highly acclaimed publications by Carl Hansen and his colleagues. Carl Hansen, I think it's fair to say, is perhaps the leader, one of the most well-respected folks in recidivism and risk assessment. And what they have shown is that there is a phenomenon of desistance, and that, again, unsurprisingly, if a person has lived offense-free in the community for a certain period of time, that's predictive of future offense-free living. And what Hansen and his colleagues have shown is that you can stratify this by risk level, and you can pick a point at which you feel that the risk of future harm is manageable, acceptable, and we can understand at what point that point gets reached. And for low-risk people, that's almost from the moment they're released. For very high-risk people, that might be 20 years and some variation in between. But the implication of that is very significant, and that is that to the extent that you spend resources on special monitoring and control of people who fall below that level of desistance, you are misallocating those resources. And those resources should be used for other prevention efforts. And number 6, I think this, Judge Huffman mentioned this, I think it is well worth emphasizing. Recidivist sex offending is a small part of sex offending. Most imprisoned sex offenders are not recidivists. Imprisoned sex offenders would be the most violent, and even among that group, only about 14% have a prior record of sexual violence. Most convictions are first-time offenders. Only 7% of those convicted of sex offenses were on the registry. 93% were not. And most arrests are first-time offenders, something around 95%. So recidivist violence is a small sliver. The serial predator model is wrong. If you want to address future sexual offending, looking at past offenders will address only a fraction of the problem. And that is that point is even more emphasized when you understand that arrests and convictions and imprisonment are all downstream. And so recidivist violence is a small part of those problems. We're not even talking about all of the unreported offenses. So Willie Sutton asked why he robbed banks. He said, that's where the money is. That was rational. And we ought to be asking, where is the opportunity to have the most effect on prevention? And the answer is probably not by addressing recidivist violence, and certainly not by only addressing recidivist violence. So this meme, this idea of the serial predator misdirects our attention. Downstream, we're ignoring root causes. Why is this happening? And it submerges sexual violence that doesn't fit this archetype. So, are our policies effective? And we can ask that in several different ways. One way of asking is, well, what's the evidence that these policies are doing what they say they're doing, which is trying to prevent recidivist violence? Number one. Number two, do these policies have unintended consequences that might be perverse? And number three, what are the resource allocation implications of our policies? So, sex offender registration notification, is it effective? Well, mixed results. A few studies have found a small deterrent effect. That's not the same as preventing recidivism. What it's saying is it's maybe deterring first-time offenders. That's not supposed to be it's not what the intended consequence was, because that deterrence is a function of punishment. Registration, the studies show, has some negative effect on criminal justice system behavior. For example, more pleading down from sexual offenses to non-sexual offenses. What there is some clarity about, clear statistical evidence looking at broad swaths of data from across the country over time. There's evidence that notification and registration laws, particularly the more aggressive they are, have the perverse effect of increasing recidivism. Well, why would that be? The very reasons that Judge Huffman was discussing, that these laws impair reintegration and the support that comes with that. Furthermore, these studies suggest that the increase in recidivism probably offsets any deterrent effect. So what you have here is good evidence. It's no doubt not conclusive, but good evidence that these laws actually harm the effort in their primary effect. Same thing can be true for banishment, residential banishment laws. There's uniform condemnation of those laws by law enforcement. Key Minnesota study found that a law in Minnesota would have no effect on preventing crimes, yet we continue to see these laws enacted. It suggests to me the operation of this moral panic, and that the idea that we are only being rational in passing these laws needs to be questioned. Other perverse consequences. Here's I think one of the most worrisome potential consequences of registration laws. Do those laws depress reporting? Again, Judge Huffman suggested that. ATSA suggests that there's evidence to that effect. I did some research using the National Crime Victim Survey data, looking at reporting rates from 2001 to 2014, and comparing reporting rates for stranger versus non-stranger offenses. And if you, the top line here, the blue line is stranger offenses, and that shows that reporting rates over these last 20-some years have been relatively stable. The worrisome piece of this evidence is the orange line, which is reporting rates for non-stranger, in other words, intimate and acquaintance crimes, and that has decreased over the very period of time that these laws, these reporting laws, have been put into place. Cause and effect, I have no idea, but correlation, yes. There's suggestions also that the serial perpetrator model misdirects people and makes it harder for people to identify sexual violence, demeans sexual violence that doesn't fit that category, and again, may impair reporting. Let me just end by saying allocation of resources, I think, is a really important thing. We have some studies that have shown highly controlled and academically sound ways, good results from certain kinds of primary prevention studies, reducing rates of rape in college campuses by up to 50%. And yet we're not spending the money on that kind of research and that kind of assessment that would help. All right, I think I'm out of time. And my end point, my conclusion, what should we be doing? We should be adopting a public health approach here, comprehensive and systematic, combination of approaches. We should be looking for root causes. What is it that causes and what is it that allows sexual violence to flourish? Should be evidence-based. We should assess. We should replicate best practices. And finally, I would say that we should be worried about the kind of legal model we're adopting when we validate the notion that there's a group of people in our society who are degraded and are not entitled to the full protection of the law. So I'm happy for questions at this point.
So, Eric, I have the first question. Minnesota has one of the most notorious civil commitment laws in the country. What has been your involvement in that as a legal scholar, and also what is the gradation from civil commitment in Minnesota to basically level 1 on the registry?
Mm-hmm. Minnesota has the highest per capita civil commitment program in the country. It's not so much that the law is bad, it's that the implementation has been affected by politics in a really perverse way. So we have, 730, I think now, people locked up, most of whom have, been there for decades. It's a huge resource drain, I think 70 million a year, something like that. Money could have been going to other things. It's a large number, but it's still a small percentage of all sex offenders being released from prison. And so, in contrast, Minnesota has a very sane, I think, registration and notification law as far as those laws go, in the sense that it's a very small percentage of people who are on a public registry. Most of the people in Minnesota are on a law enforcement only or need to know registry. So we have a contrast, I think, in that state between one of the more sensible registration SORN regimes and one of the craziest civil commitment regimes. So.
Have you been involved in any litigation around that?
Yeah, I have. I represented, I did legal work challenging the constitutionality of those laws 20 years ago. And then I've been written amicus briefs in the recent litigation. So, yeah, I'm a partisan.
Anyone want a question?
Yes, sir.
Do you believe that there's a gender bias? That's one of my questions. If we were to take Judge Hoffman's example of the 17-year-old and the 15-year-old, and if you were to change the genders from a woman and a boy or a woman and a girl, if we were to swap those around, I've been tracking this for almost 15 years, and there is definitely a gender bias, which there may be a very good reason for that I don't understand. But I also notice it in culture. I mean, our culture, we've mentioned the internment camps. We've looked at, the American Indians, the African Americans, the homosexuals. It goes all the way back to witchcraft and back to Neanderthal. I mean, humans have been doing these things. Are we bullying in society and moving, and will this move from the sex offender to whatever is next?
Yeah, so the question, is there a gender bias? I don't know. I mean, but I suspect that what the demographics, for want of a better term, of the perpetrator and the victim are, makes a difference in how we see it. I mean, for example, if you look at all of these named crimes, the ones that are elevated to paradigmatic status, they're almost all white victims. I mean, in Minnesota, one of the most prominent crimes was the tragic murder of a young college student by a recently released sex offender. His last name was Rodriguez. She was a white 20-year-old. Huge coverage. At the same time, there was a Native American woman who had gone missing. No coverage. So the notion that who the perpetrators are and who the victims are, does that matter? I think it does. Whether there's gender bias beyond that, I don't know, but I'm not sure.
Hi there.
Hi.
I think you presented really well the sort of picture of public misinformation about sex offenders. And I know that this is an extraordinarily difficult question, but I'm wondering if in your research you've encountered any strategies for sort of combating the stickiness of the myths, because I hear about the myths constantly. I've done a lot of reading in this literature and just never really hear of any strategies.
Right. Well, I think that the strategy has to take into account what the frames are, what the questions are. And I think persistent insistence on a focus on prevention and asking that question. And, you know, the corollary of that being, I know you don't care that these laws have these collateral consequences on families, on individuals. You know, I understand that you are discounting that. But you can't discount the question of allocating resources. And you cannot discount the consequences of the choices that we make when we adopt policies. Because we all agreed to start with that prevention is what we're after. You know, I don't know. I mean, I've seen some change in approach. I mean, in Minnesota, the moral panic was definitely fueled by the press 15 years ago. They are much more measured about it now. They've kind of, I think, listened to people talking about what the implications are of some of these laws. So I'm not hopeless about it at all.
We have time for one more question, and then it's lunch. Anybody else? Cindy, can I hold off for you in the afternoon? I got one over here. Okay. So you get two. You get two.
Isn't it possible that science explains people's and the media focus on serial rapists in that feminists have pushed for sexual assault kits to be tested, and recently DNA has shown several serial rapists in different states, and couldn't that explain? So one can be a feminist and believe in serial rapists. So you're a division between feminists and conservatives.
I don't deny that there are serial rapists. Of course there are. There are people who repeatedly rape, for sure. All I'm saying is that that's not the archetype. If you think of that as the primary image of what the problem is, then we get way, way down the wrong track. That's the only point I make.
Laura.
What do we know about offenses before there's an intervention? So the data about recidivism is, very widespread. We know it's low, but what do we know about the number of offenses, which speaks to the state's attorney's point about identifying serial rapists, but then there's an intervention, and then we might see a reduction in recidivism.
So you're asking, what do we know about how many offenses might have been committed before there's an arrest? Or, yeah. Well, we know that in general, multiple offenses before a person, before there's an arrest or intervention, for sure. Which, all of which emphasizes the importance of reporting and crime solving, and of lowering barriers to reporting, lowering disincentives to reporting. And then it also, if you want even a bolder approach, then you get to programs like they have in Germany and some other places where there are opportunities for people who are offending and not pleased about their own behavior to get help without risking becoming placed into this degraded group of people who are outsiders. So I think, what's the program in Germany, the Dunkelfeld program, that, would we ever think of that here? I mean, what if it could be shown that that kind of program was much more effective in reducing sexual crime than registration? I'll tell you one thing, it's not as satisfying because you don't get to shame people.
Can you just describe that a little bit, Eric?
Yeah, I'm not an expert on it. Maybe Robin has more information about it. But there are a number, there was a program here in the United States also called Stop It Now that was run out of Vermont, I think. And they all have the same principle, and that is that they're trying to remove barriers for people who are either thinking about offending or actually offending, who in secret, obviously, who would like to stop because this offending behavior is upsetting to them. And we know that in this country, there are huge impediments for anybody coming forward and trying to get that help because of mandatory reporting laws and so forth. That's a choice we've made. Is it a smart choice? Well, you know, why don't we figure that out? Why don't we figure out which of those pathways actually would prevent the most violence? And we can also ask which are more consistent with our values and those sort of things as well. But prevention is a common denominator that actually has some empirical basis to it.
Go ahead. Eric has your microphone.
Hi. You had mentioned, you said prevention is supposed to be our focus. Unfortunately, some of these offenders, they don't have a place to go to get the help before they offend, which is in Germany, they're able to get this help, which would prevent them from offending, which would prevent future victims. That's our problem here in this country. You have to wait until the person offends, and then you have a victim, and you have an offender. That doesn't help anybody. And it makes things worse.
Anybody else? Oh, go ahead, Jennifer.
I just want to ask for a clarification. I'm hoping that I misunderstood. A woman over here asked about serial rapists and how many offenses they may have done prior to their arrest. And I believe your answer was that they've committed many of them?
No, I don't.
I'm sorry.
I wouldn't generalize. I would say that it's no doubt the case that
is that across the board, or is that with?
No.
Are you speaking across the board of
I'm
sexual
not.
offenses or of serial rape? That they would have more than one victim.
The question I thought I was answering is it possible that there is prior offending behavior before a person is first apprehended or intervened with? And the answer is yes, it is possible. Oh yeah, and I think I'm aware of kind of one study that suggests often multiple offenses. I don't know how methodologically sound it is, and certainly it doesn't go for everybody. I mean, some people are discovered on their first offense.
Go ahead. And then after this, I'll give you a little bit of information about our lunch. Here you go.
Are there places where certain like sex offender treatment programs are in place in like middle schools, or places where it would be more preventative?
Oh, yeah.
Instead of kind of like what the lady was saying, after they get incarcerated, now they have to go to sex offender treatment or whatever.
You mean places where there are programs to try to? Yeah, for sure. Yeah, there are. And I mentioned this program. Actually, it's in the slides. I mentioned it. This Charlene Sen, researcher in Canada, did a double-blind, very highly disciplined study in a college-age setting that she says, published in New England Journal of Medicine, had a 50% reduction in the incidence of rape. So yes, there are studies, but she also points out that even though her program had demonstrated benefits, most universities, who also have programs, don't have evidence-based programs. So again, one simple, straightforward thing to do is to allocate money for assessing programs and replicating them, those that work. That'd be a very straightforward thing, both, not just in colleges, but in middle schools as well. And by the way, that's, your exact point is, folks who are taking a public health approach are saying exactly that.
Well, I want to thank Eric very much, Eric Janus. Thank you for joining us.